Hi everyone, and welcome to today's webinar on reducing data privacy risk under CCPA and GPC. I'm delighted to be your host today. I'm Thomas Adumo, Chief Privacy Officer at Didomi, a company that offers a privacy tool suite to comply with regulations across the globe. As we begin our discussion, I just wanted to do a bit of housekeeping and wanted to introduce the Yes We Trust community to our audience, at least for those who are joining for the first time. The goal of the community is to create bridges between experts, such as G1 and Todd today, encouraging knowledge sharing and learnings. Yes We Trust offers a variety of formats. So we've got a LinkedIn group. There are events, webinars, and today's session is a prime example of what it looks like. We've got blog articles and emails where we curate the best content on a bi-monthly basis. Now, I'd like to give our speakers, G1 and Todd, the opportunity to introduce themselves. They'll share a bit about their background and expertise. G1, would you like to start, followed by Todd?
Hello, good morning. Thank you, Thomas, for having us present on the Yes We Trust webinar this morning. My name is Juan Serrato. I'm a partner in the San Francisco office of Baker Hostetler. We're a full-service firm, and we work in global privacy risk management. Before joining Baker, I served as Chief Privacy Officer for Relics Group globally, and after that, I was Chief Privacy Officer for Fannie Mae. So I have a little bit of insights into what you might be going through in terms of trying to keep track of the evolving and changing privacy landscape.
And thanks, Juan, and thank you, Tomas, for having me on this panel. So I'm excited to participate in this very interesting topic. Todd Ruback, I'm a managing director at FTI Consulting. I have been in privacy either as an attorney or a consultant since 2005, really focused at that intersection of privacy, ad tech, and digital advertising since 2012. Here at FTI, I built out an ad tech center of excellence where we help organizations operationalize their approaches and processes to comply with these really difficult requirements that are coming out of the privacy laws, such as CCPA, CPRA. Even though I'm an attorney, I'm a recovering lawyer. I like to say I lead the law to experts such as Juan, and I help operationalize it.
Thank you, Todd. Thank you, G1, and thank you both for participating today. So let's have a look at the exciting agenda that we've prepared for today's webinar. So we'll be diving into three main topics, all crucial in understanding and navigating CPRA and or CCPA as updated by CPRA. First, we'll cover the CCPA enforcement learnings. We'll explore the lessons learned from the Sephora case and how it has shaped the interpretation of SEL under CCPA. Then we'll cover the purpose limitation principles in the CCPA as updated by CPRA. Lastly, we'll delve into the practical steps that businesses can take to comply with the updated regulations. So with these engaging topics lined up, we're all set for an interesting and insightful discussion. But first, we have a timeline that highlights the key milestones in the journey of the CCPA. So while there has been several important events since the inception of the CCPA, we're mainly going to focus on the most recent and significant developments. The deadline for adopting the final CPRA regulations was initially set for July 1st, 2022. However, there was a significant delay in the final regulations were eventually adopted on March the 30th this year, so less than a month ago. And I just want to, looking at this, I just want to emphasize the upcoming enforcement of the CPRA, which will begin on July 1st, 2023. The California Privacy Protection Agency, so the CPPA, and the California AG will be responsible for enforcing the updated regulations. So with this in mind, let's dive deeper into our discussion. Let's get started with our first topic, and that's the changes brought by the CPRA. So we're looking at a table outlining the differences between the CCPA requirements and the CCPA requirements as updated by the CPRA. So this comparison will probably help us understand a bit better the impact of CPRA on businesses. Jiwon and Todd, I have a question for you. It's a bit of a general one, but is CPRA changing everything for companies trying to comply with CCPA?
I'll start and I'll have Todd chime in. So as you said, Tomas, CPRA is an amendment to the CCPA, and the California regulators prefer to refer to the CPRA as CCPA as amended by the CPRA. So in terms of terminology, what we anticipate we're going to hear from the California Attorney General's office and also from the new California Privacy Protection Agency is the enforcement of the CCPA as amended by the CPRA. So it is a mouthful, but just to make sure everyone understands, CPRA is not a separate law. It's an amendment to the existing CCPA. And so CCPA now has been amended. And what it has done is to clarify some of the legislative intent related to ad tech and the regulation of targeted advertising. So the definition of sale versus share, the use of the sensitive information for purposes of targeted advertising. So that area has been clarified, and some other areas have been expanded. So like the right to correct, that's a new right under the CPRA, and the right to opt out from profiling, that is a new right. Some of the business obligations are new, like the privacy risk assessment and the cybersecurity assessment, and the regulations related to AI and the automated decision-making, that will be new under CPRA. But otherwise, most of what was already in effect in January 2020 for CCPA continues to live on. And so I would say those are the notable differences between the two laws, what has changed as of January 1, 2023.
Yeah, and I don't have anything to add. I mean, it's really important. I agree with what you said, Jiwon, to look at them as one law, just modified, or the way I like to describe it as the CCPA has evolved. And it's important to have an appreciation for the evolution of the CCPA and some of the things that you now need to do as a organization, including I would, I'm sure we'll talk about this a little bit later, but incorporate risk assessments into your normal everyday practice, your privacy program practice. That's really important. It's just good hygiene that we'll talk about shortly. But these I fear that the new CPRA obligations are not getting the attention that they should. So I just want to highlight that at the beginning of this conversation.
That's a bit strange because from my perspective, but it's perhaps because I'm in Europe, I see things slightly differently. I felt that with CCPA, many companies were actually flying, or like they thought that it was okay to fly under the radar, when now it feels like with CPRA something has changed, and there's this perception that nobody, or like no company, can actually fly under the radar anymore. And so I wonder why this is happening with CPRA when CCPA has been around for a few years already.
I really like that comment, Tomas, and I'm glad to hear that. I think part of it is probably just over time, right? I think it takes time for the businesses to build and to get the resources needed to call experts like you, Tomas and Todd. And so I think that is part of it. So let's say a budgeting cycle, let's say is 2 years. So for some of the larger enterprises, for calling technical vendor solutions and to get consultants, outside counsel budget, et cetera, I think that's part of it. But I think substantively what's different, and in terms of the risk for the companies, what's different between CCP and CPRA is that focus on purpose limitation, is that focus on opt-in consent, which I know you have some slides and some questions for us to really kind of delve into. And I think that's really what's probably driving this, is that I think CPRA is an evolution, as Todd said, of the CCPA, very much focused on consent, which I don't think a lot of the companies can just assume that this will be complied with. It has to be intentional, and there has to be resources addressing these requirements. It's not going to happen overnight. So I think there is a recognition by the companies that this is different. And perhaps, as we're probably going to talk to next, the Sephora settlement. Our firm has been dealing with enforcement actions for two and a half years, almost 3 years now. But the Sephora settlement from last August, I think, did shed more light publicly to the enforcement actions that have been already happening. So I think it does make it a little bit more tangible for those that have, are trying to identify the risk.
And if I could just add on before we talk about Sephora case, I couldn't agree more. I think the Sephora case was a watershed moment. And this is what, no one ever likes to have an enforcement action brought against them, but enforcement actions are really useful because they give clarity on a number of issues. Number one, the California, gave clarity that they intend to enforce aggressively. And Jiwan, as you have shared ad nauseum before, Sephora is not the only enforcement action. It was just the one that was announced and got the most publicity. But they've been very, very active in enforcement, and they've been consistent in saying that they're going to be active in enforcement. And the second clarification is that the Sephora case, or at least the AG, resolved any lingering ambiguity as to what is a sale. And in fact, I just got off a call, just before this webinar with a client, and this is not the first client that has said, well, based on Sephora, we have reevaluated whether we're engaged in a sale or not. And so there's significant events and impact of Sephora. But I just wanted to share those two observations at the front end of this.
That's consistent with what I've heard for many years, where companies were just saying in their privacy policy most of the time that they were not selling. any data, and that they were not getting sold data as well, so that they didn't really have to comply with CCPA. And I agree. I feel that the Sephora case made really a difference, and so that's the perfect transition for our next slide, where we want to talk about the Sephora case a bit, since it remains so relevant and applicable even under the or despite the CPRA regulations. And so you touched on it, Todd, a bit, but I wanted to ask G1, since you worked on that case, how does the Sephora case change the understanding of what constitutes a sale under CCPA, and why are businesses changing their approach to this?
Yeah, sure. So first, disclaimer, I am participating in the webinar in my personal capacity, and my views expressed today does not represent my client's perspective. So we've had the privilege of working with Sephora in defending against this investigations and the ultimate settlement with the California AG last August. And one thing that a lot of people don't really realize is that the investigation had been going on for over a year. So although the settlement was just announced August of last year, we had been working, cooperating with the investigation for over a year. And so there were a lot of lessons learned. And because we were not just representing Sephora, but we were representing other clients too, I'll say that a lot of the lessons learned, this is very consistent. The message from the California AG has been very consistent. It has been consistent for since July, as you saw in the timeline. July of 2020 is when we started seeing the enforcement actions from the California AG. We started working with some of the other clients, even starting from 2020. So I love this slide that Didomi and Tomas has prepared in terms of the 3 takeaways. I really think that these are the 3 takeaways if you were to deduce what businesses should take away from the Sephora settlement. And the number 1 is, as Todd and Tomas said, it really was for Sephora the question of, is the business selling or not? And as you can see, if you're taking a look at the complaint, when the notice of violation letter was delivered to Sephora, Sephora's position at that time was that it was not selling. In the course of the year, in the course of working with the California AG, the company agreed as part of the settlement that it was selling as defined by the CPA. And with the guidance of the California AG, the definition of sale became more clear. So hopefully that is helpful. If you take a look at the judgment, there is a new definition of sale using online tracking technologies. So that is a term that we negotiated with the California AG, because that's not a term that's in the statute. That's not in the regulations. So this is the first time that the California AG has put on paper what they believe to be a sale. So sales using online tracking technologies now has been defined as part of Sephora settlement. And therefore, if you are, take a look at the definition. If you are engaging in the use of ad tech and making available personal information to third parties for targeted advertising purposes using online tracking technologies, now you need to say you are selling, and you need to make it clear in your privacy policy, and therefore follow along with lesson 2 and lesson 3, which is that you need to give the opt-out right to the consumers, and you need to have a service provider agreement for the processing activities that fall outside of those sales. I know this is a lot. I know that I might be talking a little too fast, maybe, but it is a complicated legal analysis. But hopefully, the settlement and the judgment itself has been helpful for the business to reevaluate some of these questions.
And if I can also just add on point lesson or learning number 1 regarding a sale, so many of my clients. Oh, again, disclosure. I'm speaking in my personal capacity, and these are my personal opinions, not that of my company. But ad tech is such a broad term, and it's just become almost a vernacular term. It's important for the privacy officers and counsels just to keep in mind that a sale, at least coming out of Sephora, doesn't necessarily mean an economic benefit. It could be any sort of a benefit, right? Including analytics, something as innocuous as analytics. So it's a, do you want to? I don't want to, put on my lawyer hat too much here, but the term sale has such a broad meaning that it almost it encompasses every sort of activity that the ad tech stack would be engaged
in. And I was going to ask a question regarding this. So it's not clear to me yet, but if Sephora had entered into service provider contracts with its ad tech providers or analytics providers, would that be like, would the Attorney General just like give up on the case and be like, this is not a sale since there is a service provider agreement? That's point 3 on the slide. But I'm trying to understand, like, if the issue was about the fact that it was a sale or the fact that there was a contract missing.
Yeah. So as you correctly point out, Tomas, the question about service provider agreement was very central to the investigation and to the alleged violations. Again, the way that these investigations work is that these are alleged violations, and the facts that are in the complaint are not facts that have been agreed to by the party. So I like to point out that these are the facts as the way that the AG interprets the law and the AG believes are to be violations. So on its face and publicly disclosed is the fact that the AG believes that the service provider contracts that Sephora had in place were deficient. So those are the alleged facts, again, that the party may or may not agree to in terms of whether that is correct or not. Those are the alleged facts by the AG. Now, what we have learned as outside counsel, setting aside what may or may not have happened for Sephora, because we cannot disclose the specific facts of the investigations with Sephora, what we have learned as outside counsel, as we have worked with multiple clients, is, and I understand that you have some European-based clients on this call as well as US-based clients, I am hearing loud and clear that a GDPR, GPA, data processing agreement, or an SEC, standard contractual clause, is found to be deficient for California purposes. So that's really one thing, practical tip that I have found, is that a lot of our clients, especially ones that are European-based, oftentimes have a GDPR-compliant contract in place, a DPA in place that is satisfying the GDPR. And I know, because I have been a global privacy officer before, you don't want to, I've managed thousands of these contracts, right, with vendors and very, very sophisticated third-party oversight management programs. You don't want to. So absolutely, I agree with you that this is a pain. But what we are hearing loud and clear from the regulators is that even if you have gone through the exercise of updating your service provider contracts to comply with GDPR, you need to take another look, re-examine whether those contracts are specifically responding to the CCPA requirements, and there is a difference. There is a difference between a GDPR required contract for processors versus a service provider contract under the CCPA. So what we have found, when we are responding to these enforcement actions, is that almost none of our clients had that in place, especially for the ad tech world. Ad tech world, some of these media buys are media insertion orders. They might not even have a written contract, much less a privacy and security term. And very, very limited number of times you will have a compliant service provider contract that's required by the CCPA. So almost none of our clients that we work with had the full 100% compliant service provider contract. So sure, Thomas, to answer your question, if a client had 100% inventory, you knew exactly what contracts needed to be in place, all of them happen to have a CCPA service provider contract term in place, sure. But that is a magical reality that I just haven't seen.
Yeah, and also in the ad tech industry, there are like so many players that it's almost impossible to have a direct contractual relationship with all of them.
That's exactly right. And I think that's why really the inquiry is number one, right? And I think that's why so many of our clients are saying, to the extent that number three is impossible, to the extent that you cannot have a written contract with all these ed tech providers, and they will not have a service provider contract that is compliant with CCPA, then the option is to treat them as a sale. And that's why I think so many companies are starting to say, fine, we agree with you that there's a sale because number three is impossible to meet.
That makes sense. I think we should talk a little bit about GPC as well, because that was one of the key learnings from the Sephora case. So what's the situation with GPC now? Like, is it changing with CPRA first? It feels like it's actually the opposite. We're really going in the direction of like almost officializing GPC or any other opt-out signals that may be used by the industry. But how do you, as a company, how do you make sure that you comply with GPC signals when users have opted out, and also how do you deal with third-party providers, such as the ad tech vendors that we mentioned or the analytics providers, to make sure that they comply with the GPC signals? Or do you send the GPC signals to the vendors you work with? What's your take on this? Todd, maybe you have an idea?
Yeah, look, it's really hard is the answer. And you know, the global privacy control, the signal, this is nothing new, right? The expectation is mentioned in the CCPA, and the expectation of the AG is that companies will adhere to it. You know, they will recognize it and honor it. And that's an operational function, which requires a big technical investment and lift on behalf of organizations that need to comply with the law. And it requires a big commitment. And that means if a California consumer is using a browser that has the GPC signal turned on, that a company needs to be able to recognize the ping, you know, and that this is a opt-out signal coming through, and then functionally honor that opt-out signal. So when the next time that person shows up, the ad tech, the cookies, the pixels, the web beacons will be won't fire, will be, the website will be configured so to recognize that this person is back and has opted out through this valid opt-out mechanism. And a lot of companies haven't done that. And some organizations I've spoken to have said, well, our consent management platform does it, so we're in good shape. But they haven't gone through the exercise of actually validating that this has been operationally, that it has been operationalized, and not only on their websites, but in all environments where they interact with their customers, their consumer. So mobile, connected TVs, et cetera. It's a big thing. And I think this is a risk area that companies are not necessarily giving the right amount of attention to be candid.
Yeah, I would say starting this year, we're getting a lot of calls, probably several a week, for clients that are looking to implement the GPC response program. So this is probably the one big takeaway, difference between last year and this year. Again, because of the Sephora settlement, it is really clear now that GPC is part of the CCPA requirement, is not something that is new or future thinking or CPRA. This is already here, and they are actively enforcing it. Again, we have been hearing it for 2.5 years, but for some of the clients, this is now the publicly stated enforcement action specific to the GPC. So there should be no doubt at all that GPC is a legal requirement that is in place for California. And the way that Todd explained is exactly right. I think people kind of confuse what GPC is. So, say it really, really simply, GPC is a specific browser or an add-on to a browser that a consumer uses. So the consumer is taking the extra step to say, I want to use this particular browser and this particular add-on that has the global privacy control. And I am taking an action to actually exercise that right. And I want to turn on the global privacy control signal. So think about how many consumers are actually doing that. And if the consumer is actually doing that, you better be sure that this person really cares about the privacy. They have actually taken proactive steps to do so. Now, if there is a consumer that has taken these extra steps to turn on the global privacy control, the company's response, the obligation by the consumer, by the business, is to respond to it, recognize it, and treat it as an opt-out. Now, what you said, Todd, is really interesting because you said next time. So that's, I think, the area that is in the works because the regulator expects GPC response to be immediate.
Yeah.
Immediate, not next time, but now, during the same session. The legal requirement, however, to respond to an opt-out request is 15 days. So this is, I would say, a gray area where us, outside counsel, we have been, negotiating with the California agency. What does that really mean to respond immediately to a GPC response, whereas the law says it's 15 days to respond to an opt-out request. So there are definitely, everything is fact-based, depending on, I would say it really depends on first analysis, the number one analysis. What type of sale is happening at your organization, and what is your opt-out program? And depending on what sale processing is happening and what your opt-out program is, then you layer on top of it, how does GPC play into it? I have not found that there is the one size fits all. Obviously, the program that we have built for Sephora is not going to be the same program that I built for other clients. It depends on the sale processing activity. It depends on how your opt-out is designed. It depends on your architecture and your information security systems and the way that you interact with the third parties. So we know, because we have been working with a lot of clients in operationalizing this and testing it, that was what was required under the AG. So we have a lot of knowledge in how to do this. It's just a matter of putting in the right resources and investment behind it. It is not easy. It is not a one size fits all.
And
that's really interesting. Sorry, Todd, go on.
Yeah, no, Juwan, you raised a great point. I did say next time, and that was purposeful because you raise the example of regulatory expectations being very high and exceeding current technological capabilities, right? Where and that gap between expectations and what's technically feasible, or in some cases practical, that gap is a risk area.
Yeah, I agree. But I would say that we have found a way to meet the regulator expectations. So I would say really, really simply, and I think we probably need to go on, but I could spend hours talking about this, obviously. I think the three of us could talk, for hours talking about this. I would say just on that point of kind of what's technically feasible. We have gotten to a place, I think, negotiating with the regulators and telling them about the limitations. For example, GPC is mobile specific and it's browser specific. They understand that. They also understand that the downflow to the third parties, that takes time. What they do know, however, is that cookie suppression can be immediate, right?
That is correct.
The regulators are very practical. They know that certain opt-out flow down will take time. Certain other opt-out implementation, like cookie suppression, can be immediate. So I would say they are very practical. They have They are pretty technically savvy. They have been working on this for over 10 years. The do not track signal is not new in California. They have been, enforcing this for the last 10 years. So they know the technical limitations, and they expect what the business can do to be done now.
Absolutely.
So it's almost
right.
like you have to show that you're working in good faith to make it work. That's
Exactly right. Yeah, I think a lot of I think it's frustrating and overwhelming to think about all the technical limitations. What I try to do when I'm counseling clients to say, yes, we understand all the limitations. And by the way, the regulator also knows it too, because we have been communicating to them, so they know what the limitations are. What the businesses are required to do is to work within those limitations and do what you can. The good faith effort and telling a good story is absolutely what they're looking for.
And one last thing on this topic, since it's so interesting, would you what would be the basic steps you would encourage your clients, both of you, to take in order to comply with GPC, or like to build a GPC response program? Like, would you say that using a content management platform, for instance, is like the step one, at least to make sure that you can actually interpret the signal and then send it and share it?
Yeah. So as preparation for this webinar, I know the three of us talked about this. It is absolutely necessary to bring in the technical folks into the conversation. This is not something that the lawyers can do on their own. This, I would say, is a three-legged stool. One is legal, the legal analysis of what are we doing, what are we not doing, and what's the position that the company is going to take. What's your risk tolerance, and how are we going to address global risk and California risk specifically within the global risk landscape? Number one, legal. Two is compliance. And that's where consultants like Todd can be helpful. It's really operationalizing what are we going to do about it now that we know what the legal requirements are. And then third, the technical. And the GPC response requires coding. It's header information, really. And so, I think I've done enough of these operationalizing of the programs to kind of know a little bit about how to respond to the GPC. What we have seen in our experience is the in-house engineering team together with a third-party tool solutions provider like Didomi is really what you need. We do have some clients that are trying to build all of this in-house. I would caution you against wishful thinking, that you can just use a third-party tool and be done with it. I know that some of the tools offer an easy button, but when we look at that easy button, if it is as easy as turn on the GPC tool at a third-party tool, it probably is not meeting the regulatory expectation, because all it's doing is cookie suppression. That's fine if your sale practice is ending at the cookies. But most of the time, when we did the legal analysis with the clients, your sales practices are not limited to cookies. You have other practices, other data transfer mechanisms that fall under definition of sale, and that you cannot do by turning on a button. You really need to understand the list of process activities that fall within this definition and tie it oftentimes to your CRM database. And that's where I think that in-house engineering team needs to work with the third-party solutions tool.
That makes sense. I'm being conscious of time, actually, and so I think we should move on in the presentation. Just a quick one on this specific slide. I think we wanted to touch on the enforcement landscape of the CCPA. We see that, and we already talked about it, that the California AG and the CPPA will play a significant role in enforcing the regulations. The Sephora case was just one of many enforcement actions, one that has been keeping lawyers busy for a very long time, but it's only the only one that has become public so far. But with the dual enforcement authorities of the CPPA and the AG, can we actually expect an increased enforcement activity moving forward? Todd, maybe.
Sorry, I was on mute.
Sorry.
Look, yes, and what is interesting to me is the fact that there's dual enforcement authorities, and I'm interested in your insights, Yuan, about how the each one of the enforcement authorities in California is approaching that. If they're doing enforcement actions in tandem or independently, and if independently, if they're coordinated. But it just adds one more layer of complexity to the whole landscape.
Yeah. So short answer is yes. We should expect more enforcement authorities coming out of California, because the new Privacy Protection Agency in California is a brand new agency with its own staff, with its own particular agenda of what they want to communicate in terms of enforcement priorities. Completely new staff, completely new budget. So you can really kind of think about the California AG's office and the CPPA as completely two different entities bringing parallel enforcement on this law. And this is a very first state-specific privacy agency. There is no other state enforcement agency in the United States. So this is akin to something like the CNIL in France or the UK ICO. So imagine California being one of the largest markets in the United States, and I believe number 4 in globally. So, but California being a big market in and of itself, the AG's office, I believe, has a budget that is equal to the FTC, the Federal Trade Commission, and so it's the largest. I think it's the largest law office in the state. So it's a very powerful authority agency in California and globally, and now we have a separate privacy agency focused on this. In terms of enforcement activity, I want to make a distinction here. The dual authority in the law is to give the civil enforcement authority to the AG, meaning the complaints are filed in the courts. And that's what happened with Sephora. The complaint was filed in Northern District of California, and it is adjudicated in the courts. For the CPPA, the enforcement activity is going to go to the administrative law judge. So the civil authority remains with the AG. The administrative enforcement authority remains with the agency. And that's how the two agencies may bring parallel enforcement, as you said, Todd. They could cooperate and decide on the target companies. They could bring it together. They could bring it separately, all of the above.
Do we know the budget of the CPPA?
I believe is I want to say 10 million, but I am not 100% sure about that. I know that they are.
How many people are working there?
I know that they're hiring. I believe they have something like 10 openings right now.
Okay, that's good. They're working on the enforcement muscle.
They are.
Okay, that's interesting.
And they just hired, as you probably saw, Lisa Kim, who was the drafter of the CCPA regulations for the California AG, just got hired by the agency. So they were able to poach one of the deputy attorney generals who played a major role in the CCPA to be the lead counsel on the CPPA.
Thank you, Jiwon. I'm just looking at the time again. So let's perhaps quickly move on to the next topic, which explores another intriguing aspect of the CPRA regulations. I'm talking about the purpose limitation principle, and according to this principle, there are from what I understand, purposes for which only require an opt-out mechanism, while consent sometimes may be required when a data processing purpose is not compatible with the original purpose for which the data was collected. So, Jiwon, perhaps can you shed some light on whether the new set of regulations actually require consent for certain purposes?
Yeah. So this is probably the biggest regulatory focus I am hearing informally, during coffee chats and messages, and also formally during enforcement activities from the regulators, both from the California AG side and also on the Privacy Protection Agency. This is going to be the regulatory focus this year in 2023 and beyond. And I think this is something that the FTC, at the federal level, is also focused on too. So I'm really seeing a shift in terms of US privacy. And perhaps for European-based clients, this feels familiar, because I think this is the kind of legitimate interest conversations that we've had in Europe already for many years. And in the US, I'm seeing a shift where the regulators and the legislators are starting to move away from notice and consent. We're, I think, recognizing that 10-page, 15-page, 20-page privacy policies are perhaps not the best way to give notice and to say that you have a consent on particular type of data processing. And so really, I think the regulators and the legislators are recognizing that. And so the flaws of notice and consent, I think, is now being supplemented by this concept of purpose limitation. So the reasonable expectation, whether or not this was in the notice and you're buried in your 15-page privacy policy or not, and as you saw, we're starting to see a GDPR privacy policy and a California privacy policy and a Virginia privacy policy. The whole thing is a mess. And so I think this purpose limitation and the reasonable expectation of the consumer is really where this is heading. I think the regulators understand that, and they are going to be focused on it. What I am taking away in terms of practical impact of this is that pre-2020 in the United States, the regulated data was specific to, before 2020, what the US considered to be sensitive. And that was limited. It was things that would cause a data breach. So social security number and credit card numbers, the stuff that is regulated by financial regulations and health regulations. Post 2020 with CCPA, think about purpose limitation being applied to website behavioral data, to analytics, to your shopping cart, profiling of shoppers, to your cookie management. That's the data that is now in scope for CCPA and for 6 other state laws that are CCPA-like. So in the United States, the landscape has completely changed, where we are now regulating ad tech. And ad tech and targeted advertising and purpose limitation needs to be applied to the same level of rigor that used to be applied in the United States to financial data and health data.
Yeah, and
sorry.
This is, look, we're I'm going back a ways, where in 2008, 2009, when Congress almost enacted a ad tech sectoral privacy law, and then it died when the economy crashed. We're now seeing that reemerge in the form of these state consumer privacy laws that are really focused on the regulation of ad tech, and CCPA is a prime example. And Juwan, what you said is just so powerful around the expectation of data minimization. Gone are the days where organizations can use online tracking and these technologies could just hoover up, can vacuum up everything that was within its reach. Now it has to be very specific and can only be used for the reason that it is being collected. And that is puts a big burden on the organization to make sure that is in fact occurring. Because, right, even though there's 500, third parties on your website, ad tech third parties on your website, it's really a strict liability approach. The regulators want one back to pat and one throat to choke, so to speak. And it's your job to make sure that these vendors that are on your website, with your permission, are collecting only that which they need to do X, to perform the analytics, to in order to serve an advertisement, in order to provide ad attribution, whatever it is. That's very complex again, and all that kind of bubbles up into the emergence of this new governance frameworks that we're seeing. I know we're running out of time shortly, but CPOs are now being challenged to design and incorporate ad tech governance into their overall privacy program. Whereas these things may not have existed even a year ago. Now there's an expectation that they're going to exist and they're going to be robust.
And so what's the goal of those ad tech governance program? I would call them, like, what would the goal would be to what, like limit the number of vendors that are present or like active or accessing data on a specific website?
Not necessarily to limit, but to make sure that you have clarity as to whoever is on your website, whatever tracking technology is on your website is intentional and is doing something specifically that where you can deploy the right not requirements, but where you can control the activity either through technical, functional, or contract.
I would say, Tomas, this is the one area that I was really impressed with Adobe. I know that you have real-time tracking of the online tracking technologies on a website, and that's probably one of your best selling points in comparison with the other tools. And I think that real-time tracking really kind of empowers the legal and compliance folks to take action, as Todd said, because you don't know what you don't know. I think that not understanding all the third-party ad tech vendors and the cookies that are on your website probably is the one single thing that creates the most amount of legal liability in this area for this particular topic that we're talking about today. And outside of CCPA enforcement, I am getting on the phone after this call to talk about litigation. In the United States, we have seen a healthy dose, very, very active litigation on third-party cookies and pixels and whatnot. And so it's not just regulatory enforcement, but on litigation too. And so just understanding what is on your website and who's collecting what and how personal information is being made available to these third parties, just the inventory and real-time monitoring of it would allow legal and compliance folks to take action. But you can't take action if you don't know.
No, that's a really good point. I think it's very similar to what we've seen in Europe in 2018. I feel like California or the US in general is going through the same steps that happened pre-GDPR or like right before GDPR, when the first step is actually to just understand what's going on your digital properties. You want to know who's accessing data, who's sharing data with other companies. So I think that's what we call piggybacking in the US. And so it feels like it's really what's currently happening is really this the same. It's actually the same patterns that we've seen before.
Yeah.
In Europe.
Absolutely. I think it's a global trend. So California had a law back in 2003 that required websites to have privacy policies. And then that was further on amended to require privacy policies for the mobile apps. So again, the California AG has been enforcing this for 20 years, over 20 years. It's an evolution of it. I think CCPA gives the most teeth to it. And now they're actually putting resources behind enforcing it. So maybe that's why a lot of companies are hearing about it. But I think there was something like in 2016, there were 100 companies that were, Kamala Harris, the former attorney general, brought an enforcement action against 100 mobile apps. So this is definitely not new. It's a particular focus of the California AG. It has been going on for decades. And now we're really seeing teeth and the burdensome, how burdensome these investigations are, how expensive they are. Setting aside the physical, the actual fine, monetary fine, but how disruptive these enforcement actions can be, I think is what we are trying to kind of share with our clients.
Thank you, G1. I just noticed that we only have a couple of minutes left, and I just wanted to make sure that we had enough time to maybe address the two questions that we had in the chat. There's a question from Ari. So if each partner company specifies CCPA and CPRA, are they individually handled and guided? Sorry, I couldn't see that. Independently of their will by AI on the network.
I'm not sure what it means, specify CPPA or CPRA. I don't understand what that means.
So maybe Marion's question, like it's more like a guess at this point, like what percentage, like
really good question, Mario. So this is an area we can geek out about this for hours. On the one hand, the legal requirement is that the businesses needs to keep track. So you got, on the one hand, opt-out requests by individual consumers need to be tracked, it needs to be recorded, and the business needs to say this many people opted out using our opt-out mechanisms, and we have complied with it. That's one side. On the GPC, a lot of times you don't know who they are, right? So we are really kind of seeing a distinction between logged out users who are just website, drive-by visitors.
If I may, G1, I think the question is more how many people are, or like what percentage of people are actually going to adopt or like install the extension, the add-on on their browser. I think it's
So what I was going to say is we don't have a lot of companies that are tracking how many people are opting out using GPC. So I would say anecdotally, what I've heard is that if you're taking a look at a total number of unique website visitor to a particular website, how many are coming with the GPC, the number is quite small. Number seems to be going up with an increased publicity, but a lot of our clients are really not tracking. And the reason for not tracking is because GPC is not really tied to a particular individual, right? It's tied to, it's again, device specific, it's browser specific. So I could be on multiple devices and multiple browsers. And so it's not a true one-for-one tracking. So it's hard to know, if Juan on Chrome versus DuckDuckGo, my laptop versus mobile, although GPC doesn't work on mobile. So there's no way to really track the percentage of users.
Thank you both. I think we're running out of time. And it seems like we've addressed a couple of questions. So I'd like to take this opportunity to thank everyone for joining us today, and of course a special thank you to you, G1 and Todd, for sharing your valuable insights and knowledge on CCPA. We hope that this webinar has provided you with a deeper understanding of the evolving privacy landscape. Please stay connected with us through the Yes We Trust community on LinkedIn for more information, more information on CCPA, but also on other topics. And so once again, thank you for joining us, and we wish you all the best in your ongoing efforts to ensure privacy compliance. Have a great day, and thank you, G1 and Todd.
Thank you.
Thank you for having us.
Bye-bye.